In today's My Carolina Today legal advice, we're getting the ins and outs of who gets what when a couple splits up. Joining us from Gaylor, Wallace & Hunt is Nicole Taylor. Nicole, oftentimes people are surprised to hear that assets like their 401k are marital property that gets divided, even if just one of the spouses earned that money. Why is that?
Well, they are surprised, but the reason that is North Carolina is an equitable distribution state.
Which means, in plain talk?
In plain talk, that means that it's not important how the property is titled, whether it's joint or titled in just one party's name. But what is important is when it was acquired.
So what if this person had started a 401k before getting married? Well, what happens then?
It gets a little more complicated.
Of course it does.
Of course. Well, marital property is defined as property that the parties earn, either jointly or individually, once they get married, up to the time they separate. Now, if a party owned, for example, a 401k before they got married, the balance on the date of marriage would be their separate property. But what they contribute during the marriage would be marital property.
Okay.
And so it gets a little complicated because then you have to trace out what's marital and what's separate.
Sure, sure. Now, are there some other sorts of exceptions to that rule, especially when it comes to having small business involved in the marriage, perhaps?
Yes. Well, the general rule is if the asset was earned during the marriage, then it's marital. But there are exceptions. Not only property that you owned before marriage is separate, but if your separate property generates some income during the marriage, then that's likely to be separate property. So, for example, if you owned some stock before you got married and it just kicked off some interest and dividend income during the marriage, that income would be your separate property.
Wow. Okay. Is this the reason why so many people are considering prenups?
Yes, and that's another exception to the rule. If you have a premarital agreement,
okay,
it can possibly address whether certain assets will stay separate, even if they are earned during the marriage.
What kinds of information do you need to identify with marital property and debts when it comes to the IRS?
Well, what you need to really figure out what's there to divide up is there's some big ticket items. You definitely need to look at your tax returns because they're going to tell you a lot about what the holdings are and what kind of income they've been kicking off. You're going to need to look at bank account statements, retirement account statements, credit card statements, because debts are also divided.
Ah, I didn't even think about that. It's not just the assets, it's the debt as well that is divided.
That's correct. It's the net marital estate. So
and
look at
any loans as well.
Any loans. So you look at what the property is, what the debt is, and then figure out what's separate and what's marital, divide it all up.
Okay. What are some other special considerations one might want to think about?
Well, a lot of times people think that they're getting apples to apples when they divide up their property. For example, you might be getting the marital residence, and the other spouse might be getting some stock. Well, there's some tax consequences when you go to sell either one.
Okay.
One might have tax consequences, and one might not. So you really need to sort of consider the asset that you're getting, and are there any built-in tax consequences for getting it?
Wow. So a lot of complicated issues with this.
A lot of complicated issues.
Okay.
Yes.
Nicole, thank you so much. If you'd like information about this, please go to our website and click on the legal advice column. That is mycarolinatoday.com. I appreciate it.
My pleasure.